Friends, in this presentation we shall discuss the method of payment for imports. We welcome you to this project of learning export and import trade. Enjoy learning. Thanks. The payment of currency for import of the product, currency or service is regulated by provisions and guidelines set up by Reserve Bank of India. The banks which are doing international trade are called Authorized Dealers. AD provides the foreign currency and the importer must fulfill the obligation of submitting the proof of import to AD. The proof is called bill of entry. There is time prescribed within which the import should be completed. The Reserve Bank instructions are issued from time to time and comprehensive circular is issued on July 1st each year. It is called Master Circular for the convenience of bank and importers. Obligation of purchaser of foreign exchange. In terms of Section 10(6) of the Foreign Exchange Management Act, any person acquiring foreign exchange is permitted to use it either for the purpose mentioned in the declaration made by him to an Authorized Dealer Category 1 bank under Section 10(5) of the Act, or to use it for any other purpose for which acquisition of foreign exchange is permissible. Under the said Act, the rules or regulation framed thereunder. Where foreign exchange acquired has been utilized for the import of goods into India, the AD Category 1 bank should ensure that importer furnishes evidence of import, which is exchange control copy of bill of entry, postal appraisal form or customs assessment certificate, etc., and satisfy himself that the goods equivalent to the value of remittance have been imported. In addition to the permitted methods of payment for imports laid down in notification number FEMA dated 3rd May 2000, payment for import can be made by way of credit to non-resident account of the overseas exporter maintained with a bank in India. In such cases also, AD Category 1 banks should ensure compliance with the instructions contained in subparagraphs 1st and 2nd. Foreign Exchange Management Regulations 2000. Notification, Reserve Bank of India Exchange Control Department, Mumbai. In exercise of the powers conferred by Section 47 of the Foreign Exchange Management Act, the Reserve Bank of India makes the following regulations in respect of the manner of receipt and payment in foreign exchange, namely, these regulations may be called Foreign Exchange Management Regulations 2000. They shall come into effect on 1st day of June 2000. In these regulations, unless the context requires otherwise, Act means Foreign Exchange Management Act, Authorized Dealers means person authorized as an authorized dealer under subsection 1 of Section 10 of the Act. Authorized banks means a bank other than the authorized dealer authorized by Reserve Bank to accept deposits from persons residents outside India. FCNR or NRE account means FCNR or NRE account opened and maintained in accordance with the Foreign Exchange Management Deposit Regulations 2000. Permitted currency means foreign currency which is freely convertible. The words and expressions used but not defined in these regulations shall have the same meaning respectively assigned to them in the Act. Manner of receipt in foreign exchange. Every receipt in foreign exchange by an authorized dealer, whether by way of remittance from a foreign country other than Nepal and Bhutan, or by way of reimbursement from the branch or correspondent outside India against payment for export from India or against any other payment shall be as mentioned below. Group 1 member countries of Asian Clearing Union except Nepal, namely Bangladesh, Iran, Myanmar, Pakistan and Sri Lanka. Manner of receipt of foreign exchange. Payment for all eligible current transactions by debit to the ACU dollar account in India of a bank of member country in which the other party to the transaction is resident, or by credit to the Asian Clearing Union ACU dollar account of the authorized dealer maintained with the correspondent bank in the member country. And payment in any permitted currency in all other cases. Group 2, all countries other than those mentioned in 1. Manner of receipt of foreign exchange. Payment in rupees from the account of a bank situated in any country other than a member country of Asian Clearing Union or Nepal or Bhutan, or payment in any permitted currency. In respect of export from India, payment shall be received in a currency appropriate to the place of final destination as mentioned in the declaration form, irrespective of the country of residence of the buyer. Payment for export in certain cases. Notwithstanding anything contained in Regulation 3, payment for export may also be received by the exporter as under, namely, in the form of a bank draft, check, pay order, foreign currency notes, traveler's check from a buyer during his visit to India, provided the foreign currency so received is surrendered within the specified period to the authorized dealer of which the exporter is a customer. By debit to the FCNR NRE account maintained by the buyer with an authorized dealer in an authorized bank in India. In rupees from the credit card servicing bank in India against the charge slip signed by the buyer, where such payment is made by the buyer through a credit card. From a rupee account held in the name of an exchange house with an authorized dealer if the amount does not exceed rupees 2 lakhs per export transaction. In accordance with the direction issued by the Reserve Bank to authorized dealers, where the export is covered by the arrangement between central government and the government of a foreign country, or by credit arrangement entered into by the Exim Bank with a financial institution in a foreign state. Manner of payment in foreign exchange. A payment in foreign exchange by an authorized dealer, whether by way of remittance from India or by way of reimbursement to his branch or correspondent outside India other than Nepal and Bhutan against payment for import into India or against any other payment shall be as mentioned below. Group 1, member countries of the Asian Clearing Union except Nepal, namely Bangladesh, Iran, Myanmar, Pakistan and Sri Lanka. Payment for all the eligible current transactions by credit to the ACU dollar account in India of a bank of the member country in which the other party to transaction is resident, or by debit to the ACU dollar account of an authorized dealer with the correspondent bank in the other member country and payment in any permitted currency. In other cases, Group 2, all countries other than those mentioned in 1, manner of payment, payment in rupees to the account of a resident of any country other than a member country of ACU or Nepal or Bhutan, or payment in any permitted currency. In respect of import into India, where the goods are shipped from a member country of ACU other than Nepal, but the supplier is resident of a country other than a member country of ACU, payment may be made in a manner specified for currency in Group 2 of Regulation 5. In all other cases, payment shall be made in a currency appropriate to the country of shipment of goods. Manner of payments in certain cases. Notwithstanding anything contained in Regulation 5, where an import is covered by the special arrangement between central government and the government of a foreign state, the payment for import shall be made in accordance with the directions issued by Reserve Bank to the authorized dealer. Subject to the provisions of Sub-Regulation 1, a person resident in India may make payment in foreign exchange through an international card held by him, provided that the transaction for which the payment is so made is in conformity with the provisions of the Act, rules and regulations made thereunder, and in the case of import for which the payment is so made, the import is also in conformity with the provisions of the export-import policy for the time being in force. Time limit for settlement of import payment. For normal imports, in terms of extant regulations, remittances against imports should be completed not later than 6 months from the date of shipment, except in cases where the amounts are withheld towards guarantee or performance. AD Category 1 banks may permit settlement of import dues delayed due to disputes, financial difficulties, interest in respect of delayed payment, usance bills or overdue interest for a period of less than 3 years from the date of shipment may be permitted in terms of direction in para C2 of the section 3 below. Time limit for deferred payment arrangement. Deferred payment arrangements including supplies and buyer's credit, providing for payment beyond a period of 6 months from the date of shipment up to a period of less than 3 years, are treated as trade credits for which the procedural guidelines laid down in the Master Circular for external commercial borrowings and trade credits may be followed. Third party payment for import transactions. AD banks are allowed to make payment to a third party for import of goods subject to conditions as under. Firm irrevocable purchase order. Tripartite agreement should be in place. However, this requirement may not be insisted upon in case where documentary evidence for circumstances leading to a third party payments, names of the third party being mentioned in the irrevocable order invoice has been produced. AD bank should be satisfied with the bonafides of the transactions and should consider the financial action task force statement before handling the transactions. The invoice should contain a narration that the related payment has to be made in the named third party. Bill of entry should mention the name of the shipper as also the narration that related payment has to be made to the named third party. Importer should comply with the related extant instructions relating to the imports, including those on advance payment being made for import of goods. Advance remittance. Advance remittance for import of goods. AD Category 1 bank may allow advance remittances for import of goods without any ceiling subject to the following conditions. The amount of advance remittance, if it exceeds $200,000 or its equivalent, an unconditional, irrevocable standby letter of credit or guarantee from a international bank of repute situated outside India or a guarantee of an AD Category 1 bank in India. In such a guarantee, if it is issued against the counter guarantee of a international bank of repute situated outside India is obtained. A standby letter of credit is a letter issued by a bank. The bank promises to pay a beneficiary. If something fails to happen, standby letter of credit are used for the international trade, as are standard letters of credit, as well as domestic transactions. The letter of credit serves as a guarantee from the bank, which is presumably disinterested third party. If the bank's customer fails to do something like pay on time, complete a project on time, or satisfy certain terms of an agreement, the bank, not the customer who failed to deliver, pays the beneficiary. In cases where the importer, other than a public sector company or a department undertaking of the Government of India, state government, is unable to obtain bank guarantee from overseas supplier and the AD1 category bank is satisfied about the track record of the bonafides of the importer, the requirement of bank guarantee standby letter of credit may not be insisted upon for advance remittance up to $5 million. AD category 1 banks may frame their own internal guidelines to deal with such cases as per suitable policy framed by the bank's board of directors. A public sector company or a department undertaking of the Government of India, state government, which is not in a position to obtain a guarantee from the international bank of repute against an advance payment, is required to obtain a specific waiver of the bank guarantee from the Ministry of Finance, Government of India, before making advance remittance exceeding $100,000. All payments towards advance remittance for import shall be subject to the specific conditions. Advance remittance for import of rough diamonds. Advance remittance for import of aircrafts, helicopters and other aviation related purchases. Advance remittance for import of services. AD Category 1 bank may allow advance remittance for import of services without any ceiling subject to the following conditions. Where the amount of advance exceeds $500,000 or its equivalent, a guarantee from a bank of international repute situated outside India or a guarantee from an AD1 category bank in India. In such a guarantee is issued against the counter guarantee of a bank of international repute situated outside India should be obtained from the overseas beneficiary. In the case of a public sector company or department, undertaking of the Government of India, state governments, approval from the Ministry of Finance, Government of India for advance remittance for import of services without bank guarantee for an amount exceeding US$ 100,000 or its equivalent would be required. AD Category 1 banks should also follow up to ensure that the beneficiary of the advance remittance fulfills his obligation under the contract or agreement with the remitter in India, failing which the amount should be repatriated to India. Notwithstanding anything contained in Regulation 5, a person resident in India may make the payment for import of goods in foreign exchange through an international card held by him in rupees from an international card, debit card through the credit debit card servicing bank in India against the charge slip signed by the importer as prescribed by the Reserve Bank from time to time, provided that the transaction for which the payment so made is in conformity with the provisions of the Act, rules and regulations, and made thereunder, and the import is also in conformity with the provision of the foreign trade policy in force. Thanks.